Good morning. So, they got a gavel up here. I've never had a gavel. When I was chair of CFA for 6 years, I didn't have a gavel, so when I turned over my chairmanship, my wife and I drew up a bullseye that I put under my suit jacket on my back, and I turned over the bullseye on my back to the next chair. So anyway, this morning we have some government officials. First, we have in the morning Dale Cantone and Theresa Leets, and they are there. Woo, it works. And I'll let them fully introduce themselves, but this is supposed to be an interactive session. I want you asking them questions, and then following up this session, we will have 2 members from the Federal Trade Commission. So we hit state regulators and then federal regulators. And so we have with us this morning the 2, what I would call premier state regulators. Dale Cantone, recently retired, but I'm pretty sure you suck at retirement. So joining us from Maryland, and Theresa Leets, the lead regulator from California. So Dale, since it's 11:30 for you, you should be more awake than Theresa, even though she looks bright and cheery this morning. We'll let you start, give a little introduction and kind of what you do or we're doing in Maryland, and then later we'll get into the NASA stuff.
Okay, thanks, Keith. It's really good to be here at this program, and I appreciate the opportunity to speak to this fine group. Keith, thank you for the invitation, and Bob. And thank you for the opportunity to work with this organization for quite a few years now. So it's a pleasure to be here. And Theresa and I are thrilled to take the opportunity to be able to speak to people. And we hope that this is an interactive session. And if there's a way to answer questions, we would both be thrilled to do that. But I guess let me start with who I am and what I'm doing here. And as Keith mentioned, I for probably more than 25 years, was the chief of the Franchise and Business Opportunity Unit in the Maryland Attorney General's office. I retired at the end of 2021, but somehow I have managed to stay involved on a contractual basis, both with the state of Maryland as a very active member, primarily dealing with policy and enforcement matters, and then I am available to Theresa, who is the new chair of the NASAA Franchise Project Group. And for those of you who don't know what that is, NASAA is an organization of, well, for these purposes, an organization of state franchise administrators. We work together promoting policy and model laws. Some of the things we've done over the past, we actually, our group was the primary author of what was then called the UFOC guidelines, and is now, for the most part, the federal guidelines for franchise disclosure. We promulgated a commentary on making financial performance representations, which I used to call earnings claims, and Theresa will go into some more detail about what we do. So that's who I am. I'm still working on franchise matters every day. And yes, I do suck at retirement, but I do find that it's an interesting area that I enjoy, and I will keep doing it as long as I can do that. I wanted to kind of give a brief discussion. I'm assuming for purposes of this discussion that everyone in the audience has at least a basic understanding of the federal and state laws regarding franchising. Everybody knows that there's this Federal Trade Commission rule that requires a disclosure document. We call it an FDD. And in the interest of uniformity, the disclosure document is accepted by the states that regulate franchising. There's about 15 states that have a specific franchise law, depending on how you count them. And in addition to requiring the disclosure, the states can require registration of the franchise offering. They might require that the disclosure document may have some changes or make some clarifications. And then we have staff to do enforcement when franchisors violate the law. So in many ways, the FTC and the states have a very complementary scheme of regulation. And I am here to say that we have historically worked together very well. And the FTC is a fine organization that really does a good job. But what I want to talk today about, and what a lot of people might not appreciate, is the fact that the states that regulate franchising have a very different approach and philosophy to franchising from the FTC, and that those differences impact how we administer and enforce our respective laws. The difference in approach is quite fundamental and has real life consequences. It's amazing that it hasn't caused more of a difference. But you can see the differences when you immediately go to the FTC's website and see what their mission is. Their mission is protecting consumers and competition by preventing anti-competitive, deceptive, and unfair business practices through law enforcement, advocacy, and education without unduly burdening legitimate business activity. Contrast that with the legislative policy behind the Maryland franchise law, which is similar to other state franchise laws, which identifies the widespread sale of franchises has created many investment and business problems. Franchisees have suffered substantial losses when the franchisor or its representatives haven't given complete information. The law's intent is to give prospective franchisees necessary information and protect the franchisor-franchisee relationship. So at its most basic level, you can see that the FTC considers franchising as a consumer transaction, or at least it calls it that, and it is certainly handled through the Bureau of Consumer Protection. There's nothing wrong with that, but it's just the approach the FTC uses. Whereas the states very clearly and uniformly consider franchising to be an investment, akin to a security, an investment of money with the opportunity for, profit. And that is seen in the state franchise law approach, which really mirrors the state securities laws. Because at the state level, we consider franchising to be an investment, kind of like a security, but I always point out, and I think Keith also points out, that when you buy a security and it goes bad, you're going to lose everything you put into that security. In contrast, if you purchase a franchise and it goes bad, you have no idea how much you can lose, because obviously there's an opportunity to lose, be responsible for imputed royalties throughout the term of the contract or liquidated damages, and you just never know how much a bad franchised investment is going to cost you. But other than that difference, for the most part, there's a lot of similarities in buying a franchise and investing in a security. FTC does not seem to treat it that way. And again, there are some differences. I will give you some real life examples of how that difference plays out in real life. And here's an example, and I hope I'm not overstating it, but historically, the states, or at least NASAA, which is this organization of the states and kind of their policymaking voice, have promoted, advocated mandatory earnings claims, mandatory financial performance representations on the basis that that's an important piece of disclosure that prospective franchisees should have, recognizing there's difficulties with it. The FTC, however, has not traditionally mandated FPRs, mandatory FPRs, although who knows, they might sometime in the future. But they certainly have some considerations that the states don't have that might limit their ability to promote that wholeheartedly. And one of which is, you can see from their mission that one of their missions is to promote competition. And there's an argument that requiring mandatory earnings claims, I just like to call it that, actually has a somewhat of an anti-competitive effect, because some new startup franchisors may not have the ability to make the type of disclosures up front. So that is a limitation. Another example is a kind of a fairly obscure provision under the FTC law that says that franchisors have to make these disclosures, but they really don't have, that are required under the law, but they shouldn't go further than that. unless it's permitted. And the states, based on our securities laws, have a philosophy that you have to make all material information available to prospective franchisee for them to make an informed choice. And so that there might be opportunities when a particular piece of disclosure is not strictly mandated under the law, but a state could very well say, well, this is material enough that we think it should be disclosed anyway, which can cause some problems with franchisors, but it's not the first time we've dealt with that. The other obvious example, probably the clearest example, is that the states review the disclosure document and the FTC does not. And states can and often do require changes to the disclosure document and clarification, which also is an area where we come into conflict with not so much franchisors, but franchisor counsel who prepare the document and often don't see that anything should be changed in their work product. Another example, most states with the franchise law have a specific provision that prohibits a franchisor from requiring a franchisee to waive or disclaim certain provisions of the state franchise law. And Theresa's going to touch on that a little bit briefly. And then finally, there are some state franchise law that have relationship provisions. Mine does not, but certain, Theresa's does, and some other state laws, really impact the franchise relationship, which can manifest itself in imposing certain, limiting a franchisor's ability contractually to certain conditions on transfer, or to limit the scope of post-term non-competes, can even affect the prices or markup charged to franchisees in some situations. So there are really a lot of differences between the two approaches. There are a lot of similarities, but to understand why the states do things one way and the feds do something a different way, it's really helpful to see that at the very basic level, we're coming at the same issue from two different philosophies and two different approaches, and what difference it makes. With that, I'm going to turn it over to Theresa to give everybody a little bit more information about NASAA.
And Theresa, I do want to point out that I am not making sandwiches today.
I see that.
Blowing my cover.
I see that. Yeah, no more plausible deniability for you. Okay, good morning. I'm very grateful that Dale is not great at retirement. He's, as you can hear, is a national treasure when it comes to all things franchising, and we hope to keep him around advising as long as possible. So my name is Theresa Leets. I am the Assistant Chief Counsel at the California Department of Financial Protection and Innovation. I supervise franchise regulation in California. We have 8 attorneys, 3 examiners, and 10 support staff. We're located in the Securities Regulation Unit of our legal division. As you may know by now, California is the largest franchise regulator in the United States. I'm also the current chair of the NASAA Franchise and Business Opportunities Project Group, replacing Dale Cantone. So you can see why I would be very happy to have him stay on as an advisor. It is absolutely a privilege to join you at your leadership summit today. I welcome the opportunity to hear from you. This is really my only opportunity to hear from franchisees, so don't be shy today. And Dale forgot, probably because he's retired, but we have to do our disclaimer, which is that our views today are our own and not the views of our commissioner, NASAA. So if you need to say that, Dale, I just said that for you. Okay, so let me jump into NASAA. It's something that it's an acronym. It's not the space agency, as Keith likes to always tell people. It's the North American Securities Administrators Association. It's not a government entity. It is a membership organization of security regulators in the United States, Canada, and Mexico. So NASAA has been protecting Main Street investors and the integrity of your capital markets for over 100 years. So they've been around for a very long time. Not a lot of people know about us. NASAA has no direct authority over franchising in the US, but because it is an association of state administrators who regulate franchising, our recommendations, and when I say our, I mean NASAA, I'm putting on my NASAA hat, recommendations and policy initiatives have traditionally been given weight by the franchise regulation states and the FTC. So let me put this into some context. Let me tell you, so what does this mean? What do we do? How do we help you? In 1975, right? The very first franchise rule was passed in 1971 by California. The FTC didn't get there until 1978, but in 1975, NASAA adopted the first set of pre-sale disclosure requirements for franchise offerings. What does that mean? That means that we gave the guidelines to the franchisors to tell them what had to go into the FTD. So you have a disclosure document to help you make informed decisions. What we failed, and if I could do it again, I would have said that those disclosures had to be readable, right? We never said they had to be readable. And that's a problem. That's why you have 300 pages of text that nobody wants to read. But we did give them the outline of the content that needed to be in there. So in 1979, the year after the federal franchise rule was adopted, the FTC authorized franchisor to follow the NASAA guidelines. And then 20 years later, when NASAA adopted revised guidelines, the FTC again authorized the use of those guidelines. Franchisors today, they continue to use our guidelines to satisfy both the state and federal disclosure requirements. And by 2007, and this is, I'm going to give Dale a shout out, it's his leadership, that we got a whole host of policies passed to benefit franchisees. That included financial performance representations. We did commentary on that. We made sure that franchisors were making accurate, not misleading financial performance representations. We passed a multi-unit commentary. We were telling franchisors how to disclose area development, area representative, or sub-franchisor opportunities. We revised the state cover sheets. In the state cover sheets, they basically act as a navigation tool to introduce a first-time franchisee to the FDD. And finally, with the nightmare that is COVID, we were able to get commentary out for disclosing financial performance representations during the time of COVID. But what I'd really like to talk to you about is what we're doing today. So what are we doing for you today? We have a statement of policy regarding the use of franchise questionnaires and acknowledgments. So the question is, why this policy now, and why am I super excited to talk to you about it? Well, it addresses the information and power imbalance between franchisors and franchisees. And I think you know this better than I do, but let me tell you how. So franchisors often ask franchisees to sign a series of either acknowledgments or questionnaires at the time of signing. And most first-time franchisees don't understand the significance of these disclaimers. So later, if a franchisee finds out that they've been lied to and they try to pursue a legal remedy, the franchisor brings the disclaimers out as evidence and say that there was no fraud at the time of purchase and basically call the franchisee a liar. This is a classic case of the franchisor using the information and power imbalance to its advantage. The state franchise laws anticipated this dynamic and wrote the anti-waiver provisions into their laws to prevent it. So a disclaimer cannot change historical facts. If a franchisor lied, the franchisor lied, no matter what the disclaimer says. The disclaimer can only be an attempt to change the legal effect of that lie. That is why the state franchise does exactly what the state franchise anti-waiver provision forbids. So the FTC held a public workshop in 2020 to explore these issues related to these very disclaimers. Although the FTC has not yet directly addressed the issue, as Dale said, the states have a different perspective on our laws and what we can do. We're focused on investors, and we include more protections than the federal franchise rule. So this SOP is based on those state franchise anti-waiver and anti-fraud statutes. Franchisors routinely use these questionnaires and acknowledgments to try to limit their potential liability in franchise offerings. The proposed statement of policy is intended to set appropriate standards in the use of these disclaimers. So in summary, NASAA works hard to balance the playing field for franchisees. So we're not well known, but we do a lot of work behind the scenes that I think has a lot of impact. And for that, we have Dale to thank. He's been doing this, 25 years before you retired? Yep. So I'm not claiming credit. I'm just letting you know I have very impressive shoes to fill. And then I'll turn it back over. I don't know, Keith, did you want to do some question and answer?
Yep. Yes,
okay.
We will. So, and hopefully there's a little piece of paper on the governor's desk that'll make your life a lot easier in California on the waivers.
I'm counting on it. Yeah, counting on it.
So, time to open it up. We got mics running around. this is your chance. Ask a state anything you want. I would
And-
say,
and-
oh, go ahead.
I was going to say, if they don't have questions, we can jump into the enforcement complaints, because Dale and I do have some tips on how to, submit a complaint to the department, how to get us to be responsive and helpful when you do have a complaint.
So just, we've all heard the Burger M case. Dale in Maryland was the first one to say, Burger M, you can no longer sell franchises. And then, of course, Theresa and her team in California slapped them with this big fine. You haven't gone to Israel to try to find the guy yet, I don't think, but...
He'll come back. We're waiting. We're patient.
Because then the FTC, of course, went after him. So any questions? Here we got one over here. Shane?
My name is Shane Miracle with the Cell Phone Repair Owners Association. And it's probably a good segue, I think, into the next topic y'all are going to address. It seems like there's some regulations in place, but it seems really difficult to enforce some of those regulations. And in our particular case, we've been petitioning the FTC to maybe look at what's going on in our franchise system. And it seems like it's a pretty difficult task to get them to even have a look at what's actually happening, and much less take some action on it. What can we do to help the FTC take more action where the franchisees are being abused?
Well, and I'll let them answer it, but the good part is the states tend to be a little more or proactive on taking things, because I think smaller group or whatever, but either you want to take that on, and I think it leads into what franchisees can do to be heard, so you do know that something is going on.
Well, I'll say actually some of the answer probably should come from the Federal Trade Commission about what you can do to get the Federal Trade Commission to look at a particular complaint. I'm frequently shocked at the lack of complaints we get at the state level. We have jurisdiction over what happens in our state, but there are many times when a problem has been brewing for years, and then we don't hear about it until somebody finally makes a complaint to us and we can start to look at it. And I'm not quite sure why that is. Maybe people don't know where to complain, how to complain. If you're in one of the 15 states with a franchise law, you go to the state securities division or the state attorney general's office to find the right person. And in my state, all you have to do is, contact us by email or in writing, and the more information you have, the better. And sometimes we can't do something about an issue, partly because, a lot of times franchisors are very good at papering over any potential issue, but there are times when we can. And like in the Burger M case, we were able to get a hook to stop them from selling franchises that did not have to go to the ultimate issue about whether or not they were committing a wholesale fraud, which of course is an issue that is something that can only be concluded after a very lengthy investigation. So, if you're in one of the states with a franchise law, please let us know that there is a problem going on. And sometimes we can do something about it, sometimes we can't, but we can certainly start the dialogue and find out. And at a minimum, if there's an issue going on in a particular franchise system that we may not be able to help you for all sorts of contractual reasons and disclaimers and waivers, it's an area that we can watch out for the next person coming who might be buying that thing, which I know is only so much comfort if you're losing money. But it's really important to contact the states if you're in a state or if you have franchisees in a state about a problem. So Theresa, do you have anything to add to that?
Just let me add, on the FDD, in your FDDs, it lists the registration states and how to contact you.
I forgot about that. Thank you, Keith.
So what I would add, without knowing what state this actual franchise outlet is in, if the franchisors in California, or there are outlets in California, or they're registered in California, I certainly want to hear about it, right? So even though it might sound like a relationship issue, usually if you can provide me the facts involved in the sales process, Usually when people are upset and the relationship is breaking down, it's because somebody made a promise that you relied on when you bought the franchise. And it's that pre-sale, that time before you sign the franchise agreement, that we have jurisdiction. So if you're upset about something and something's not working out, it's usually because somebody made you a promise and they didn't keep it, right? And that's where we have jurisdiction. California does have a relationship law. Our department just doesn't have jurisdiction over it. And then when you do file a complaint, you want to make sure you give us the evidence. You don't want to file it as an anonymous tip, because we need evidence to take state action. And if it's a he said, she said, you have to really let us know you're willing to testify. Because before the department's going to commit resources so it can take action, we need to know we can prove our case and that we have the evidence. But I definitely want to hear about what's happening in the system if it's breaking down. And it took us a while with Burger Ream. We were getting different kind of complaints. Different people were complaining about different things. And so we usually takes us a little bit to get all the facts in to understand whether there's an actual, I'll say broken promise, maybe is the most simple way to summarize it. But we want to know about what's going on in the system as early as you can. As with Burger Ream is a great example. By the time it crashes, by the time we can prove our case, we want there to be a remedy for you. And in California, we have tons of remedies. We had one case where we had a franchisor that didn't want to honor a renewal, and we brought an action for specific performance to make the franchisor keep its promise and renew the outlet. So sometimes it's just not giving you money damages. Sometimes it's disgorgement. Rescission gets tricky. But there's a lot we can do the earlier you come to us with an issue if we have jurisdiction, to Dale's point. Sometimes we don't have jurisdiction. But if the franchisor is in California or there are outlets in California, please use our complaint process.
I would also
Yeah,
add, it's funny because people, when they come to me and go, well, we have this problem, then one of the first questions I always ask, do you have any franchisees who will come forward from California or Maryland? So, because I know both of you and your states actually act.
Oh, I mean, this is why I'm so happy to be here with franchisees. All day long when we review these documents and on all our projects, we're trying to level the playing field for you. And I want to know, are you reading the FDDs? What's working? What's not working? What could we do better? Because we put a lot of effort into making this a level playing field for you, and we know it's not, and we want to make it better. And so we need to hear from you. So don't think of us as these faraway government entities that don't care. We might be a lean, mean fighting machine, but we're impactful if you give us evidence. We can do things.
Well, we're trying to get you more staff.
Oh, well, I'm hopeful.
Any other questions? Shane, Mark.
I'll ask a second since somebody else wanted to. And I'll sort of generalize it. It's a specific issue for our franchise system, but we have a contract, obviously the franchise agreement, but the franchisor has embedded so many clauses in the contract that it's almost impossible for a layman to read it and understand what's happening. A good example is, you think you're buying a territory, and then you find your franchisor opening a store across the street from you with a different name, and you find out, oh yeah, in another section of the contract, there's actually a little clause that says, oh, well, we can open in your market, but under a different mark. And so you find yourself competing with your own franchisor in the same market, or territory that you thought you purchased. What can be done to help clean up those franchise agreements so that we avoid so many of those loopholes where the franchisees are being eaten up? In our case, in our franchise system, it's our franchisor runs two franchise systems and competes them against one another.
Do you want to start with that, Dale, or do you want me to grab that?
That's a good question. It's a very difficult question. What you're talking about is the fact that the current disclosure document is not the easiest to read for the layman, which I will have to agree with you. And I think that is something that has evolved over the years. I know when I first started doing this, the documents didn't seem quite as complicated or lengthy as they are. It's all well-intentioned trying to put all the important information about a franchise into that. So the theory is that if you have the information, you can make an informed decision. But of course, if they inundate you with information and people don't end up reading it, it doesn't do any good. The Federal Trade Commission, which is going to be speaking here very shortly, is currently undergoing a rule review, and one of the things it's looking at is whether or not there are changes to be made to that franchise disclosure document format that we talked about. The practical realities is that this franchise disclosure document is, and Theresa and I talk about this very frequently, is as much a franchise disclaimer document as a franchise disclosure document, because it has all this information in it that if somebody were to sit down and read it, would realize how very little, in most cases, the franchisor is promising, and that when something goes wrong, if a prospective franchisee says, I have this problem, I didn't think it was going to be this way, the franchisor can pull out the document and say, we disclosed. And this happens on many enforcement cases that we look at. Somebody will have the wrong idea about how the relationship should be, and the franchisor can pull out the disclosure document and say, it's right here on this page that says we can do this, and it's very clear, and you signed this document that says you understood it, you had an opportunity for a lawyer. And so unfortunately, then they're blaming the victim in this case. That happens very frequently. That is unfortunately something that's very difficult to address. A franchisor lawyer will tell you, well, you should not have signed a franchise agreement that you didn't fully understand, which is really disingenuous, because I have to tell you, I've done this for so long. I don't think I could, understand a lot of these franchise agreements and the full impact of it without taking a lot of time. And I'm a lawyer, so it takes a lot of time, it takes a lot of effort. A lot of first-time franchisees don't use a lawyer. They're all excited, having talked to a broker or a salesperson. And I think that's just the reality. What could be done about it? We try to make some efforts in that regard. That one of the things Theresa mentioned was this state cover sheets, which have some, a guideline about how to go over the document and some specific risks that appear in every franchising. I mean, franchising is, let's face it, a very one-sided deal. There's no doubt about it. It's very one-sided, and you have to know what you're getting into, and most people do not. But I mean, short of changing the disclosures that are required, the government philosophy is not to interfere in what two people contract for, generally, with some limitations. The government laws mostly deal with how can we get prospective franchisees to know what they're getting into. And it's a very difficult answer. I'm not sure that I'm having any good answers here, Theresa. If you do, feel free to jump in.
What I would be itching to do is to look at the FDD that you signed, to look at item 12, and to see whether or not they promised you an exclusive territory or not. Because sometimes they promise you an exclusive territory and they do these carve-outs, and once they do the carve-outs, they aren't exclusive anymore, right? You can't say, you have an exclusive territory, but the minute you hit but, right, it's no longer exclusive. And so they do some very creative describing of these territories. So I would go back, and this is what I meant when you file a complaint with the state, or in California, go back to the FDD. What were you promised? Why did you have this expectation that you weren't going to be competing with the franchisor, and that you didn't expect the franchisor to be your number one competitor? What promises did they make before you signed the franchise agreement? And so that gives me the most leverage at that point, because then I'm dealing with my anti-fraud statute, which is really broad, and the commissioner has a lot of authority. And if the commissioner feels like you were misled and there was a misrepresentation, then we have the most authority to act, because our burden of proof is a lot less than an administrative action. So that's why it's really important to look at the FDD and to give us a copy of the FDD, and to make sure they did everything else they were supposed to. Did they give you a receipt on time? Did they, comply with all the other laws in California? All I need is one opening, one hook, right? And then I can go in and try to make everybody whole if I have a violation in one spot. So it's, like Dale said, it's tough, but I'm not afraid to jump in and look at it. If somebody made you a promise to think that you weren't going to be competing, or that the franchisor wasn't going to be your number one competitor, let's look at that. Let's see what we can do about that. But it's awful. I think there was a study where somebody studied item 12, and they said you needed, what, 20 years of an education to understand the nonsense they put in that? I mean, it should be really easy. Here's the territory you get. Either it's exclusive or it's not. What do we mean by exclusive? What do we mean by not exclusive? And most franchise territories today are not exclusive. And I've seen a lot in this space in complaints. I had one item 12 where the franchisor sold the same people the same territory. That's how outrageous some of my complaints have been about territory. But it is really complicated and hard to understand. So don't feel bad, right, ever, anyone, if you go through an FDD and you don't understand it. Apparently, I don't even have enough education 20 years into it, right, to understand an item 12. Item 12. So that's one of my, I could advise the FTC to do this over again, in addition to all these in the state's regulation, we need readable disclosure. We need disclosure that people can read and understand. And we understand that's a flaw in our regulatory system.
So we're going to take one more question. I just warned you, Sam Levine, I know, is dialed in already, so quit throwing the FTC under the bus now.
We're not. We're
no, I'm just
counting on
teasing.
them.
I'm just teasing you. So, Peter?
Theresa and Dale, glad you're here. Sam, glad you're here. I would like you guys to explain to the audience the remedies that you guys can affect, including a notice of violation and a rescission for franchisees that buy franchises in your states with misrepresentations or they fail to make their disclosures. What can you do to actually give a remedy to the franchisees?
Good morning, Peter. As you know, and California has the most generous grant of authority of any franchise registration state. We can almost do anything that is equitable that you can think of, everything from a stop order, a rescission, restitution, disgorgement, damages, injunctive relief, specific performance, all these fancy words for making you whole. So our ability is very fact specific. So I gave the example of specific performance. A franchisor didn't want to renew a franchisee. We were able to grant specific performance so that they had to. It can be damages. It can be disgorgement. It's hard to do rescission after a contract's been in place and people have been earning a living and money. It's hard to put people back in time. So we'll do something like disgorgement. But it's very fact specific in California. I am very lucky, and that's why sometimes it takes us longer to do enforcement action, because there's so much we can do that we really try to get all the facts. So when we take action, we can make people whole. And so I'll let you hear what Dale can do.
We have similar remedies in Maryland. The most common remedy we seek and get is rescission, but it's a form of rescission. It's our form of rescission that often is the return of the initial fee and getting somebody out of a franchise agreement, which, by the way, is nothing to be sniffed at, because without a rescission offer, you can't get out of these franchise agreements, even if you're losing your shirt. That is the most common remedy we get, and we get that generally without having to go to court, usually by agreement. But if the statute gives us the authority to go to court and have similar remedies, as Theresa mentioned, disgorgement, injunction, even getting a receiver. I got very frustrated with a franchisor in an enforcement case that I'm currently looking at, and I will tell you that I even threatened them with going to court and getting a receiver to take management out of its current role and putting in a receiver to operate it in its place, which is a pretty extreme example and probably would not be in the best interest of anybody. But it is something under the law that gives us that ability to do something like that. So.
Okay, and I guess we have one more quick question. Be quick, and then we'll bring Sam on. Who was the question? Oh, just getting the mic there.
Hi, I'm Krista Adams, and I live in the state of North Carolina. So while you've been speaking today, I've been looking at your website, and I did come across the states that do have regulations. And in North Carolina, we're a no for franchise regulation, but we're a yes for business opportunities regulation. So I two-part question. How do we change the franchise from a no to a yes? And what's the difference between business opportunity regulation and franchise regulation?
I can take that. Business opportunities, think of them as kind of a lower tier version of a franchise. Probably the main difference is a business opportunity generally doesn't include the use of a trademark. So sometimes we have trying to decide whether something is a franchise or not. If there isn't a trademark, it could very well be a business opportunity. Examples would be, buying a bunch of vending machines as an investment opportunity and getting location assistance. Just this morning, I had a case dealing with somebody who agreed to set somebody up in a beauty supply store and gave them all the tools in order for them to get operating in a beauty supply store, everything, but said you can use whatever name you want. That would actually be a business opportunity under our law. So there's a little bit of, there's not a lot of overlap. In my opinion, something is generally either a franchise or a business opportunity. There's not a lot of overlap. As far as how you can get, your state to go from a no to a yes, it's purely up to the state legislature. I will tell you, in the 25 years that I've been doing this, no state has thought seriously, well, they've thought seriously, but no state has adopted a new franchise law, and several of them have dropped their franchise laws. So it doesn't seem to be something that is in vogue at the moment. A lot of time franchisors have very powerful lobbies that can point out that it's anti-business, which is nonsense, because you guys are the business people that we should be protecting, as opposed to the larger business person who is often out of the state. So I don't know, but that's something that a lot of the franchisor lobbyists have been very good at. But it's purely up to the state legislature, and it's up to the citizens of the state to lobby their state legislators if that's what they want to do.
Yeah, I mean, it's tough in a state to add something. I was going to ask you, when was the last time a state added an investment law, because that's what we're talking about. And I think the opposition would say, well, we have the FTC heavily regulating this industry already, and they would pull enough votes with that one comment. Of course, we know that there is no heavy regulations or heavy enforcement of regulations, but that would be a tough one. If you look at a lot of the states that actually have the laws, they had them before the FTC really had formed the franchise rule. California, like Theresa said, went in effect in '71. So you had these states that did it before the federal government, and actually would argue that the franchisors wanted the federal government to finally do something, so they didn't end up with 50 state laws to try to hang on to. So, well, great. Actually, Theresa and Dale, if you want to hang on in the background and listen to what Sam says and maybe keep Sam out of trouble, we'll pop Sam in now. But thank you both very much.
Thank you.
Thank you.
There's Sam. Good morning. Well, no, it's afternoon now for you, Sam. How are you doing?
I'm doing well. Nice to see you, Keith. And Dale and Theresa, always nice to see you as well.
So Sam is the director of the Consumer Protection Bureau at the FTC. So basically there's three bureaus in the FTC. You have the commissioners, and then you have three directors that run. There's competition, yours, and what's the third one?
Economics.
Okay. I never have to deal with them. So Sam, do a little introduction of yourself and what you do and how franchisees can help, and then we'll take some questions.
Sure. So it's really great to be here. This is not my first AFD meeting. I had an opportunity to join many of you when I worked for Commissioner Chopra 2 years ago, who was a commissioner at the Federal Trade Commission. So as Keith said, I lead our Bureau of Consumer Protection at the FTC. And our jurisdiction covers pretty much just within the Bureau, covers pretty much the entire economy. Our core statute, Section 5 of the FTC Act, prohibits unfair or deceptive practices in commerce. And when we encounter those practices in any sector of the economy, we have the authority to take action, and we do. And that action can take the form of rulemaking, can take the form of lawsuits, can take the form of market studies, requests for information, and we have some other tools as well. Our current chair is Lena Khan. She was appointed by President Biden last summer. And she made very clear from the beginning of her administration that fighting for small businesses and for franchisees in particular was going to be a major priority for her. So what I thought I would do briefly today, and then I'm looking forward to taking questions from Keith and anyone else, is go over some of the things we've been doing in the franchise space over the last year, and then again, take questions and talk through what the future may hold. One sort of preliminary point, Keith mentioned that I lead Bureau of Consumer Protection, and then we have these other bureaus as well. One of the goals Chair Khan has made clear is that our work in this space and in many spaces should be cross-agency. It should not just be within our Bureau of Consumer Protection. So in addition to our work on franchise issues, we coordinate closely with our Office of Policy Planning, which often will weigh in on state legislation and state bills. We work with our Bureau of Competition, which enforces the FTC Act's prohibition on unfair methods of competition. And we work with our technologists who play an increasingly vital role in the agency in making sure we understand tech developments at the FTC. And we do work, Keith, with our Bureau of Economics as well. So much of what we do has profound impacts on the economy, and we always benefit from the economic expertise that our Bureau of Economics brings to our work. So I would say there's sort of 5 categories, 5 general areas where we've been working on franchise issues over the last year. Law enforcement, consumer complaints, policy work, franchise rule review, and partnership with the states. In particular, 2 of our favorite partners happen to be on this call, Dale and Theresa. So let me start with law enforcement. So we are primarily a law enforcement agency. Most of the work product kind of coming out of our agency are lawsuits. And we actually brought the first lawsuit alleging a violation of the franchise rule in a decade and a half last summer against a company I'm sure you're all familiar with, Burgerine. We actually referred that case to the Department of Justice. They are litigating it on our behalf. It remains in litigation. And one thing our chair said at the time is it reflects a renewed commitment across the agency to protecting franchisees from illegal practices, and that's very true. In addition to our lawsuit against Burgerine, in November of last year, we approved an order with 7-Eleven. 7-Eleven was in the process of acquiring certain locations, certain convenience stores from Marathon Speedway. And among other things, we required that 7-Eleven divest 124 fuel outlets. And it really critically prohibited 7-Eleven from enforcing any non-compete provisions to any franchisees or employees working at or doing business with the divested assets. And I think what we did in that 7-Eleven matter illustrates how the FTC does its best work when it's working across bureaus. The review of that merger was undertaken by our Bureau of Competition. But I was familiar, and the Bureau of Consumer Protection was very familiar with some of the issues facing franchisees. And we were able to work with the Bureau of Competition to secure an order that I think is going to make a big difference to a lot of franchisees who will no longer be bound by non-compete agreements. Another thing we did was late last year, we issued more than 1,000 what are called notices of penalty offenses. This is a new tool we are using to businesses throughout the country, including a number of franchise businesses. And what we made clear is 2 things. 1, if you misrepresent how much money people are going to earn from a service or product, that's a violation of the FTC Act. You can face civil penalties. You're probably wondering whether that is also a violation of the franchise rule, and in many cases, the answer would be yes. But we wanted to make it very clear that we have multiple tools at our disposal. If you lie to someone about how much money you're going to make, that's illegal under the FTC Act, and we can take action. And we also sent a notice of penalty offenses around what we call endorsements. So for example, if I tell you that this is the greatest pen ever made, it's a precise V5 pen, and I don't tell you that on the side I'm getting kickbacks from whoever makes it, Pilot, that's a violation of the FTC Act and something we can get penalties for. And we know that it's not, we know that there are a lot of businesses that engage in this type of practice. So part of what we did with notice of penalty offenses is make clear that companies could pay a price for engaging in them. So that's sort of what we've been doing on the enforcement front. We've also made a concerted effort to get more franchisees to file complaints. We have an outstanding resource, reportfraud.ftc.gov. We collect millions of complaints a year from all over the country and in some cases the world. We have dozens of law enforcement agencies contributing complaints to our system. We also give dozens of law enforcement agencies access to complaints on our system. So report fraud is an absolutely critical tool for us and for law enforcement all over the country. And I can't underscore this enough. If you want to get issues to be front of mind for law enforcers, whether at the state level, the federal level, or anywhere, filing complaints at reportfraud.ftc.gov is absolutely critical. Last year, we actually did usability testing to make sure that it was straightforward for franchisees in particular to file complaints. And we modified our complaint portal to create a dedicated path to file franchise complaints at reportfraud.ftc.gov. And I'll certainly be interested in hearing if people have worked with the system and how their experience has been. I know I've gotten some very good feedback so far. One thing to note, though, is that we are not getting a ton of complaints from franchisees. And I'll be interested to hear if people have explanations for that. In 2019, we got about 750 complaints. Last year, we got about 1,000 complaints. It's an increase, but it's really kind of a drop in the bucket relative to the millions of complaints we receive every year. So one point I really want to stress is the best way we can do our work and respond to the needs of franchisees is to hear from them directly. We do not have sort of supervisory authority. We don't have examination authority like other law enforcers. We're not inspecting premises. We need to hear from real people with real problems in order for us to act on them. So that's what we've been doing on the complaint front. We've also been active on policy work, and I would point to two moves in particular that I think are significant. First, we actually filed an amicus brief in a case that many of you may be familiar with, Patel v. 7-Eleven in Massachusetts. There was a question there about whether an individual who is a franchisee under the franchise rule may be deemed an employee of the franchisor under Massachusetts wage law. And our brief argued that the franchise rule requires franchisors to make specific disclosures to franchisees, but does not address whether a franchisee is an employee or an independent contractor, and it does not preempt state law. The Massachusetts Supreme Judicial Court, top court in the Commonwealth, agreed with us and found that there was not a conflict between franchise rule and Massachusetts state law. I think that was an important win for the franchisees in Massachusetts. But the broader point we were trying to make, I think, through that amicus is that the franchise rule is intended to help franchisees, not to be used not to be weaponized against them when they are trying to assert their rights. And that speaks to another policy initiative we undertook.
Actually, Sam, if I could interrupt on that one a second, because that was a huge ruling and an important amicus by the FTC. I know we also am a director on the Coalition of Franchisee Associations, and we actually related to the lawsuit in California because they had a similar lawsuit in California. And the IFA and the franchisors asserted that, well, the franchise rule overrides the state law in these cases. And Ron Gardner, who will be given an award tonight from Dady and Gardner, actually gave an opinion to us that if that ruling was upheld, that the franchise rule could overrule or set the standard of that law, potentially all state laws, all state franchise laws could be preempted by the franchise rule and wiped out. So the FTC acting in this is no minor minor thing and literally could have saved all of our state franchise laws.
Thank you for making that point, Keith. And I really want to thank Christine Todaro, who manages our franchise program at the FTC. She's not visible, but is on this call. We have a team that are monitoring developments in the franchise space throughout the country, including they were the ones who spotted this dispute in Massachusetts. They're in regular touch with many of you. They're in regular touch with Dale and Theresa. And I think that just underscores how Chair Khan has made clear, I've made clear, this is a priority for us, and we have people working really hard at the agency to try to make sure our franchise program is robust and that franchisees are protected. So big thanks to Christine for helping to make that amicus brief.
And hello, Christine, and yeah, we can't see her, but I think the other exciting part is historically it was just Christine or just, I'm drawing a blank on Craig Trigillis before, but you actually have kind of a team that works on franchising, and it's not just Christine anymore, which I'm sure she's happy that she has other resources and help.
Yeah, look, it's a team because we know how important this issue is. We know how many jobs are affected. We know how many entrepreneurs have staked their livelihoods on the franchise business model. We know that this is really about being able to realize the American dream for a lot of consumers. So we're certainly making this a priority, and I think that's reflected in what we're talking about. And, just going back to what I said about the franchise rule, it wasn't only that we filed an amicus, we also tried to clarify another, I think, misunderstanding that some people may or may not hold. And that is whether franchisees can bring lawsuits under state law. So let me just back up and get a little bit nerdy about law for a minute, if you indulge me. So the franchise rule is an FTC regulation promulgated under the FTC Act. The FTC Act prohibits unfair deceptive practices, says that the FTC can write rules to prohibit specific unfair deceptive practices. We used that authority many decades ago to write and promulgate the franchise rule. There's no private right of action under the FTC Act. You cannot go into federal court and assert that you've been the victim of an unfair deceptive practice under the FTC Act and seek relief. However, almost every state has what we call a mini FTC Act, which is a state law that replicates the FTC Act in prohibiting unfair deceptive practices. And in many states, I think most states actually, consumers do have a private right of action and can bring claims in state law asserting that practices are unfair or deceptive. So we issued a clarifying blog post a couple weeks ago under my byline where I tried to make clear the franchise rule, there's no private right of action under the franchise rule, but the franchise rule reflects determinations by the FTC that the practices prohibited by the rule are unfair or deceptive. For example, providing inaccurate financial performance representations would be almost certainly a violation of the franchise rule, unfair, deceptive after practice. The point we made in the blog post is that consumers may not be able to sue to enforce the franchise rule directly, but franchisees can, depending on their state law, bring cases in state court alleging that unfair, deceptive practices violated state law. Now, I'm not saying those lawsuits are going to succeed, and obviously you want to consult your attorneys and familiarize yourself with their particular state law you're operating under. But the headline point I wanted to make is that nothing in the franchise rule, nor in the FTC Act, precludes franchisees from bringing claims under state law regarding misleading performance representations or any other violations arising or related to the sale of a franchise. And I'm happy to talk about that more or to share a link to the blog post if that would be helpful. Last thing I want to know, or two last things I want to know before I turn it over to questions. We've been talking a lot about the franchise rule. Well, as I think all of you know, that rule has been under review. We launched the review of the rule. We initiated it in February of 2019. We hosted a pretty major workshop. I can't remember now if that was in 2020 or 2021. But we explored earnings representations and whether the commission should mandate earnings representations under the rule. We explored franchisors' use of disclaimers and questionnaires, and we explored the format of the FTD, topics that I know all came up in the previous session. We also sought additional comment in conjunction with that workshop, and we received about 120 of them, which is great. That rule is still under review, but it's something that we're paying a lot of attention to. Last point I want to make, and I think I've already said it, is that the franchise team we have at the FTC is working very closely with the folks who are really on the front lines of making sure franchisees get a fair shake. And those are our partners at state attorneys general and state regulators, including Dale and Theresa and folks in states all over the country. We really value our ability to work with our state partners. We learned a lot from them. Our own administration of the rule is informed by their important work. So I'm really happy to be able to be joined by our state partners on this at this conference. So that's sort of a high-level overview of the various things we are doing in the franchise space. I think you're going to see there's going to be more to come, as this is a continued priority for the agency. But the message I will leave you with is that keep those complaints coming in. The best thing that can inform our work, whether it's the rule review or our enforcement work or penalty offense follow-up or amicus briefs, is knowing where the problems are. And the best way for us to ascertain that is by hearing directly from franchisees. And with that, Keith, I've talked a lot. I'll turn things back to you.
Oh, great, Sam. And kind of one other note, as we know, the GAO was doing a study and a report, and actually we do have the GAO here doing roundtables during this conference with the franchisees here, which is great. And, you know, I think I hosted one roundtable yesterday. We had moving roundtables, I guess, or something like that, different sessions, and I hosted one on filing a complaint and the process to file a complaint. And I think the one question that always keeps coming up is, how many complaints, what does it take for the FTC to start taking action? I know that's a simple question with a complicated answer.
Yeah, no, that's right. Look, we have a staff of 350 or so people in the whole Bureau of Consumer Protection. And they're responsible for protecting consumers in every sector of the economy. You know, 1 week we'll announce a major action against Facebook. Then the next week there'll be a franchise case. Then the next week we're doing Made in USA apparel. Then the next week we're doing false environmental claims. The breadth of what we do is quite staggering. So we have to be very strategic in where and how we marshal our limited resources. So if we're getting kind of a very small trickle of complaints about a given, let's say, franchise, that might be an indicator of a deeper problem. But it becomes a question, do we invest the very significant resources to pursue a case, such as putting together a civil investigative demand, a pre-litigation subpoena, serving it on the franchise, reviewing potentially tens of thousands or more documents based on just a handful of complaints? And that can be hard to do. What we really look for in our complaints before we open an investigation are patterns. They're patterns. So if we're hearing persistent patterns, say we're hearing about the same practice. I mean, we heard, you know, without getting into the specifics of some of the lawsuits we brought in the franchise space. We have brought those lawsuits because we heard from a number of sources in a number of ways that were clearly deep problems. So when it comes to whether to open an investigation of a given franchise, you know, probably we're going to want to hear from a good number of franchisees alleging pretty similar practices that we believe may be unfair or deceptive. And Keith, would it be helpful if I got into what it means to be unfair or deceptive?
Yes.
Sure. So these are not just kind of terms in the FTC Act, and we get to decide what they mean. We have to prove it to a court, and there's a lot of case law, and it's actually in our statute too, on what these terms mean in the case of unfairness. So a practice that's deceptive a claim is deceptive if it's likely to mislead a consumer acting reasonably under the circumstances. It's somewhat straightforward. If a practice is likely to mislead people, it's probably deceptive. It's more complicated than that, but that's a good high-level summary. Unfairness is a little more complicated, and it's a lot harder to prove. To prove a practice is unfair, we need to show that it causes or is likely to cause substantial injury to consumers. The term is substantial injury. We need to show that that injury is not reasonably avoidable by consumers. So basically, the consumers could not have protected themselves from the harm. And we need to show that the injury from the practice is not outweighed by countervailing benefits to consumers or competition, which I'm going to oversimplify a bit, is basically a cost-benefit test for whether it makes sense to bring the action. Again, that's an oversimplification. So those are sort of that's the authority we are working under. So again, to go back to what I was saying, if we want to prove that a practice is unfair, that it causes substantial injury that's not reasonably avoidable, we're going to want to show that a lot of people got injured, that a lot of people got hurt. So sort of individual disputes will generally not rise to the level of something that, we can bring a federal lawsuit to hold.
So you use the term consumer there, and there's always been this debate. Does the FTC view a franchisee as a business to business or the franchisee as a consumer?
It's a good question, but it's kind of an irrelevant one. And I say that with all due respect to my good friend.
I'm asking it. I think I know the answer, but I know it's one that I get asked all the time.
Yes, no, absolutely. Franchisees are consumers. Franchisees are consumers. They're consuming, I know I'm not going to use, they're consuming franchise opportunities. It's a very regular part of our work, in fact, to take on cases using both the deception authority and our unfairness authority, involving sort of not, if you think of a traditional consumer as someone kind of, going to the department store and buying products, that is one type of consumer. But we've brought cases certainly involving practices that target franchisees. We've brought cases around practices that target gig workers, like Uber drivers or Amazon Flex drivers. We bring cases all the time around practices that target multi-level marketing distributors. So it is not an unusual thing for us to bring cases involving small businesses, franchisees. It is true that the word consumer does appear in the FTC Act under the definition of unfairness, but we believe and we have good support for this. That is a broad term, and we are prepared with the right evidence to bring cases involving franchisees, just as we would with kind of more traditional types of consumers.
Okay, do we have some questions? I have a couple.
Hey, you have Patrick Findaro, co-founder at vettedbiz.com. We're a media and data company, mostly focused on the franchise industry. And Sam, I have to give my applaud to your organization as we request a lot of FOIA requests for information on franchise complaints, and your department gets it to us like within a week. And a lot of that information we publish to show what's going on and how a lot of franchise brands are not acting in a nice way with current franchisees, and prospective franchisees probably should not be getting into those systems. The SBA, though, on the other hand, has not been as forthcoming with providing franchise disclosure documents, and they have FDDs on 6,500 documents on franchise brands that have been approved for SBA lending over the last 5 years. where I think consumers would greatly benefit if that was open and that people could see those documents freely, and that firms like Vetted Biz could report on those findings, as it would just allow the consumer to compare apples to apples on a much larger data set.
Yeah, it's a really thoughtful suggestion. Let me say this about the SBA. I think we are really keen to work more closely with the SBA, because as all of you know, they play an absolutely critical role in the ecosystem in getting franchisees started into the system. You know, I've shared with Keith that one of my formative experiences in the consumer protection world was prosecuting for-profit colleges early in the last decade, 2012, 2013, 2014. And one of the dynamics we saw in that space, you had sort of misaligned incentives. You had these for-profit schools who were telling prospective students that they could earn a lot of money by signing up for the school. And the schools didn't always care whether the students were actually going to make money, because the students were able to get loans from the federal government, from the Department of Education, to fund their education and enroll in the schools. So you had a little bit misaligned incentives where the schools didn't have an interest in actually seeing the students succeeded, because they knew that even if the student is totally incapable of succeeding in the school, they can bring in these federal loans and make the school a lot of money. I am not saying that we're seeing the same dynamic in franchise. I'm not suggesting that, but I'm always interested in business models where you have a third-party funder, which is often administered through the SBA, who's different than the actual company offering the opportunity. In my case, it was for-profit schools. In this industry, it's franchise. One of the things we're doing in the higher ed space at the FTC, and this is really, I think, I'm quite proud of our work here, is we're working very closely with the Department of Education to make sure people are protected on the front end, because we know that they have a lot of power to make sure that unscrupulous schools are not continuing to collect federal funds and benefiting from federal lending programs. I would like to have an equally close relationship with the Small Business Administration. I think they could be a vital partner for us. And I hope that can, I hope we can strengthen the relationship with them over the years to come.
Okay. Shane?
My name is Shane Miracle. I'm with the Cell Phone Repair Owners Association. Thank you very much for coming in with us today. Appreciate it. My question is, first is a little bit of a statement. I feel a little bit like a David and Goliath, except that I was required to hand my slingshot to Goliath prior to stepping on the battlefield. The task of pushing back against the franchise just seems daunting and almost impossible to win. They have franchise agreements that are, I'm sure, complied to all the requirements of the FTC and state regulations, but they seem to, work around between the lines, and in our case, we're constantly inundated with requirements to sign a new release, so we're constantly signing legal releases for any change to the system whatsoever. My question is, how do we feel like there's any sense of hope to ever get onto a level playing field against the franchisors? I mean, what can we do to move the ball, so to speak? It sounds like submitting more complaints is a fundamental piece of that, and I'm glad I was here this morning to hear that piece, because I'll certainly be proactive in pushing that. The second question you asked earlier was, why are y'all getting so few complaints from franchisees? And I think there's probably two fundamental reasons why. Number one is fear of reprisal. The franchisors get very aggressive with shutting down franchisees and suppressing you in legal ways to keep you from being able to move or exit the business and do what you need to do to have success. And then number two is you feel like David on the battlefield against Goliath, and what good can my one little complaint possibly do in big scheme of things. So those are my two, I guess, statements and questions.
Yeah, it's a really good, thank you for sharing that. It's a really good question. One thing I just have to put a plug in, I think you mentioned you're at the cell phone. Tell me again the name of your franchise.
It's cell phone repair.
CPR, cell phone repair.
Yeah, no, I'll just point out another initiative that we're very proud of with the agency is we're trying to make it easier for consumers to repair their products, including by making it easier for them to go to independent repair shops to repair their products instead of needing to go back to the original manufacturer. But that's a talk for another day. Let me respond to the two issues you raised, which are, what you described as David and Goliath, with David shorn of his slingshot, and fear of reprisal. So let me start with the David and Goliath piece. This is just a challenge in American law right now. I think Dale alluded to this right before I joined. I'll get a little bit geeky here. Decades ago, like in the late 60s, courts started refusing to enforce contract terms under certain conditions. In particular, there was a famous case here in DC that found a contract term was unconscionable, and a court refused to enforce it. It was a consumer-facing consumer-facing contract. In the half century since, courts have really moved away from revisiting the terms of contracts. The general view coming all the way down from the Supreme Court is that if two parties knowingly enter a contract, that's it. They both agreed, it needs to be enforced to the letter. I will say, and that has gotten, and what that has meant is that it's become much harder for consumers or for law enforcers to challenge contract terms that might be problematic. And frankly, it's only getting harder. It is not getting easier. I'm probably not sharing anything that you all don't know. But we have had some successes at the FTC. I'll give you an example that might be relevant to actually your second point too. 6 years ago or so, we began seeing in consumer contracts non-disparagement clauses that prevented consumers from, I don't remember the exact facts, but basically prevented consumers from filing or posting bad reviews of the product or service. We brought a case against a company called Roca Labs, and we alleged that the inclusion of that term was unfair. It got the attention of Congress, and Congress actually banned, again, I'm going to oversimplify, banned non-disparagement agreements in consumer contracts. That was called the Consumer Review Fairness Act. Now look, this is sort of a narrow term, it's just one term, and it took a lot to get us there and a lot to get Congress there. But it is an example where Congress just said, you know what, you can enter into whatever contract you want, but it can't include this term. So there have been successes, but again, that was for consumer-facing contracts, notwithstanding what I said about consumers. With franchise agreements, you're dealing with a franchisee and a franchisor, so you're dealing with two businesses. I think some courts would view that rightly or wrongly as a contract between two highly sophisticated parties. I think we know that that's not always the case, but that's how some courts might view it. So you're right that this is uphill. And I think for us to be able to do what we did in Roca Labs, I think for any enforcer to be able to do to take on that kind of challenge, we do need complaints and we need hard evidence. So if there's a term in a franchise agreement, for example, that is harming people, or it's alleged to be harming people in a complaint, we'll be much better positioned if we actually know what the harm is. Is the franchisor enforcing the term? Are they taking franchisees to court on the term? We know that many franchisees sign arbitration agreements, so we don't have visibility into this. But the more evidence we can see that not only is there a term in a contract that may pose problems, but that it actually is posing problems, and there's actually evidence of the harm that consumers, that franchisees are suffering, that's going to make it a lot easier. On your second point about fear of reprisal, certainly if we have evidence, and I know that this might feel like a catch-22, but if we have evidence or we're hearing that franchisees are being told not to talk to law enforcement, not to file complaints, not to be able to speak freely about what's happening to them, that's something we're going to be very interested in. Obviously, I can't, I'm not in a position to say here now whether that's illegal or anything like that. But one of the core things we advise franchisees, for example, if they're prospective franchisees, is to talk to franchisors, talk to existing franchisors as part of the due diligence process before they enter a franchise. And if we're finding that they can't talk to franchisors for whatever reason, or existing, they can't talk to existing franchisees, for any reason, that could be a problem. Because we want prospective franchisees talking to existing franchisees. I think I was saying franchisor, I meant existing franchisees. We want that communication to happen. So if there are active efforts to muzzle people, again, I'm not saying that that's illegal, but it is a problem because it would make our rule less effective. And it would make it harder for us as a law enforcement agency to protect the public's interest.
Got a question up here, just getting the mic there.
Well, first, thank you for being here. My name is Craig Berlin. I represent Basecamp franchisees. We have two resale store concepts, one for children and one for adults. What I was talking about with the attorneys yesterday is that it seems to me that a lot of this would be helpful to both franchisees and to your agency if we could get at the front end of some of these problems. And the way I see that perhaps doing that, particularly with the internet now available, is making more information available as to what people look out for. We discussed yesterday that some people are so enamored with the concept, they don't hire an attorney at all to look at the franchise agreements, or in some cases, they may be told some red flags and do it anyway. I think the more information that you can have out there that people can find about things to look out for, the most obvious one being a requirement to go into arbitration. But if we could get on the front end of people jumping in to franchise agreements that are bad, now you can't always anticipate what the franchisor is going to do later, but if they can be aware of the potential pitfalls going in, and my experience with a lot of franchisees is they come into a situation, I mean, all kinds of people start their own businesses, but kind of when you come into a franchise, you're looking for that sort of mentoring and leadership from someone who already knows the lay of the land. And sometimes you don't get exactly what you bargained for. So I think any information you could have, resources on your website that people could see about here are things to look out for, recommendations to contact an attorney to go over your document thoroughly. I think, is there anything that the agency could do that isn't involving a lot of your limited resources that are already spread thin that could help prevent some of the problems or raise awareness to the point where they don't come to fruition?
Yeah, it's an excellent question. We're far better off, this is how I felt in the higher ed space. You don't want people to get trapped in the first instance. It's a lot harder for us to do anything, for the franchisee to do anything once they're in the franchise. We want people to go in eyes wide open about what they can expect. So we do have pretty extensive materials at ftc.gov, educational materials for franchisees, what the questions they should ask, the things they should look for when purchasing a franchise. And we continually evaluate whether that material needs updating. We are very proud of the consumer and business education we do. If you go to our website, you'll see we have education materials on just about every topic one encounters as a consumer. From buying cars, to clipping coupons, to buying a broadband service, to buying a franchise. So we do have materials on that, and I think updating it to make sure that it is addressing contemporary needs and contemporary problems in the franchise space is a great idea. The only thing I would caution, the only point of caution I would make is a point that some folks were making on in the previous discussion, which is that we don't want information overload, right? You know, most FTDs are quite massive. We hope that franchisees also look at our materials so that they can know some of the things to look for specifically in the FTD. But we are keenly aware that, and I saw it firsthand, especially in the higher ed space, that once people kind of have it in their heads that this is the way they're gonna either ascend to the middle class or make a lot of money or become the next franchise mogul, once that's in their head, it can be pretty hard to see red flags. Again, I saw this in higher ed. Once people visualized themselves getting that degree, they were pretty much hooked. And I wonder if a similar dynamic happens in franchise. So I absolutely want to make sure we have the best materials possible so that people can make educated decisions. But I think all of us are aware that this is a challenge because people aren't always in the best position to do that due diligence once they're already getting excited about the franchise.
Any more questions? Got time for about one more. I would say one thing is, let's face it, the FTC is a huge ship to move, and a lot of progress has been made since, I would call it the Lena Khan era, has moved in. It was really, I think, Sam, the first time we met was February of 2020 with then Commissioner Chopra, and he started talking about franchising, and I've joked, geez, I didn't even know franchise was in the vocabulary at the FTC because I don't think the word was uttered for a decade or so, hardly. And I mean, there's been a big change, and I think things that you've developed and this commission and with new Commissioner Bedoya, I think there's a lot in movement with franchising that we haven't seen yet, that you probably can't talk about yet, that I think we'll see some real improvement. And I do have one more question.
Good morning. My name is Greg Brown, here representing Expense Reduction Analyst. One of the challenges that I think all franchise groups have is we may go into this with a franchisor who seems to be cooperative and communicative at the time, but they're going to have a session later about private equity coming in, and franchisor leadership changes happen. I think I'm on my third CEO in 13 years. And when a franchise leadership role changes, the attitude to the franchisees can dramatically change. My sort of underlying question may mirror what Shane was asking. When something comes up, is the more appropriate action to our state or to the federal side? I mean, what's the best place to register that complaint and maybe get some attention when you're having an issue like he's having, where you got this competing franchise right across the street?
I would do both. A lot of states, I'll put in a plug, I think Maryland does it, Dale. I think California might not. Theresa, a lot of states, so every state AG has their own complaint database. I believe all of them can access ours, but not all of them contribute their complaints to ours. So what I would do is I would file a complaint in both places. It can be identical, it doesn't matter. There's no harm in, if we end up getting a duplicate, that's no problem. And just more broadly, I think what you're describing underscores why we do have concerns in this space. We know that once someone is in a franchise system, their life is tied up with it. So the franchisor ownership might change, leadership might change, business model might evolve, but it's quite hard, I think, for a franchisee to walk away even if they want to, especially if they're bound by non-compete agreements, like we talked about with 7-Eleven, or some of the other challenges we've been discussing. So again, I think the road here is uncertain. As I said, the courts have moved in a direction quite dramatic over the last few decades of really saying you signed a contract, you're bound to it, too bad, get out of court. But if we see persistent problems and persistent harm to consumers, There is work we can do, but as I said, and just returning to the point I keep underscoring, that all starts with hearing from franchisees. And I take the points that have been made that some people fear reprisal, and that is a real challenge. But it's the only way that we can take action is if we hear directly from the people on the ground who are experiencing these harms. That's what allows us to act.
And I would say, yes, there and everywhere. As I always call it, bait as many hooks as you can. You don't know where you're getting the bite. So we're at the end of your time, Sam. You probably have a meeting to run off to. Any parting words? And I guess I'll see you on Thursday, won't I?
That's right. I'll see you on Thursday. No, it's just wonderful. I can only see the people asking questions. I can't see the whole room, but it's wonderful to have been invited to speak with all of you. I have a lot of respect, as Keith always says, and I feel the same way. The franchise business model is a really promising one. I think it helps a lot of people who might not otherwise be able to start a business and succeed. But it's incumbent on us to make sure that it's a marketplace that's working fairly for people. So that's really a high priority for me, and being able to hear directly from all of you in this meeting, and hopefully in some consumer complaints too, if appropriate, really helps us do our job. So thanks very much.
Great. Thank you, Sam. Thank you, Christine, in the background, and Dale and Theresa, if you're still on back there. So thank all of you, and we'll talk soon.
Thanks, Keith. Take care.
So I think we have oh, you're going to do the, good.
All right, just a reminder, especially for the folks that may not have been here this morning when I mentioned it, little adjustments in time. 12:15 will be lunch where the breakfast was. Because you're probably hungry already, there's snacks out there for you, both carbs and non-carb options.